Good evening, councils. Ini kita langsung mulai bagaimana sih? Kalau oke, langsung mulai aja ya. Good evening, councils. Welcome to the global rounds of 2021 Philips Jessup International Lawmaker Competition. I would like the council of applicant to present this case. Applicant, chair is yours.
Very good evening, Your Excellencies and the Agent of Republic of Ranov-Style, Madam President Veby and Judge Dinata. My name is Veby Oktia, and it is such an honor to appear in this virtual court representing the state of Aprepuya as applicant in this case concerning the JFIT-18 pandemic. For 21 minutes ahead, I will address our first and second submission, and in the next 21 minutes, the co-agent Ayu Anggraini will deliver our third and fourth submission. And also we reserve 3 minutes for rebuttal. This first submission claim is regarding Ranov-Style violate international law by did not report to WHO and their issued into regulation to Aprepuya and thus obligated to compensate it for the resulting economic losses. Your Excellencies, I submit two arguments. The first, Ranov-Style violate international law by did not report to the WHO immediately and discriminated Aprepuyan with their anti-regulation and have to compensate the economic losses that Ranov-Style has caused to Aprepuya. If you don't mind to the structure, and may it please the court.
Agent, please proceed.
This issue emerged when Ranov-Style made the anti-regulation and travel restriction regarding to the JFIT-18 pandemic and put Aprepuya on their high-risk countries list, while in Aprepuya only have 9 confirmed cases. Ranov-Style assumed took that action because to prevent their citizens from the virus. But on the other hand, that gave unsavory effect to Aprepuya's economic, particularly in the tourism sector. Hence, this is the pioneer why Ranov-Style violate international law and must compensate it. Your Excellencies, Ranov-Style did not report about their anti-regulation to the WHO immediately. This is contradicts under Article 63 in the WHO Constitution, stipulates each country has to report anything about law, regulation, and statistics promptly to the WHO in the health measure context. And yes, precisely in the Article 3, Paragraph 4 of IHR affirms each state has their sovereign right to legislate and implement their legislation according to their health policies. But each state should still uphold the purpose of the IHR and the WHO itself. And is strengthened by the International Sanitary Convention. Everything that taken by a state, such as a statistic about plague or pandemic, they have to notify to the WHO immediately. Your Honor, regarding to the previous
regulation,
yes,
what is the status of that WHO regulation to the respondent?
Yes, Your Excellencies, the WHO Constitution is a hard law that has been signed by Ranov-Style country, and Ranov-Style and Aprepuya is both of member of this constitution, Your Excellencies.
Okay, please proceed with your case.
Furthermore, Your Excellencies, this is excessive measure by Ranov-Style for put Aprepuya from the high-risk countries list, while in Aprepuya only have 9 confirmed cases. But based on their third section of Ranov-Style's anti-regulation stipulate, each country will add to that high-risk countries list if there is a 50 minimal confirmed cases of that virus. It means Ranov-Style also violate their own regulation, and because of this, Aprepuya has asked Ranov-Style with good faith to erase Aprepuya from the high-risk countries list. But Ranov-Style...
Excuse me, agent. If the respondent like violate their own domestic national regulation, then why would it matter for the applicant?
Yes, Your Excellencies. Since the violation of the domestic law of Ranomstayo itself is not our matter, we only emphasize again that Ranomstayo not only violate the international law, but they also violate their own domestic law. But this is a form of not under the international regulation and also their own regulation, and but we did not interfere any punishment of the breach of their domestic law itself. We only constitute that Run of style is also violate this on their own regulation, Your Excellencies. May I continue, Your Excellencies?
Yeah, yes, you may proceed.
Subsequently, run of style discriminated Aprepuyan with their anti-regulation and travel restriction. Your Excellencies, this contradicts under Article 13 in Declaration of Human Rights, where everyone has right to live or enter any country, and country, but Ranomstayo, do the travel restriction, where as now 40% in tourism in Aprepuya, except Ranomstayan, who want to travel at Aprepuya's territory, they have to transit at Bokpadayo Airport, which is in the Ranomstayo's territory. But moreover, in fourth section of Ranomstayo's entry regulation, stipulates each individual who transit at one Ranomstayo's airport, they have to deem and follow this regulation. Thus, this is indirectly has limited Aprepuya's right, especially in the economic aspect, which is the biggest vehicle income of the Aprepuya state, Your Excellencies. And furthermore, according to their travel ban, Ranov also violate Article 12 of the ICCPR, where everyone has right of the freedom of movement, where all Aprepuyan, whether in Aprepuya's territory or not, they cannot gain their freedom to travel anywhere they want, and also all Aprepuyan that did not suspect of the JFIT Act in itself, they still they still prejudice as a danger of run of state's country and census. This is a form of a discrimination against Aprepuyan because the prohibition of entering or leaving a country without a clear reason and lack of evidence is it a form of discrimination itself, excellencies, because Run of Style did not do the process of checking first to all Aprepuyan. And this is contradicts also with Article 1, 2, and 7 in Universal Declaration of Human Rights, where everyone have to be treated equally, and this is clearly not shown by run of style to all citizens in Aprepuya.
Excuse me, agent. So, are you saying that this discrimination because of danger of the pandemic uh, is like is something that is relevant to the application of ICCPR?
Yes, Your Excellencies, even the freedom of movement is a dirigible right in ICCPR, but the implementing of the travel restriction is it a form of a diminished in the JFIT Acting, and we did not uh, oppose the action of Run of Style itself. What we contradicts here, it's about there is no exclusion to all Aprepuya citizen of Run of Style's country, where all Aprepuya cannot leave or enter any country of their country itself, and cannot go to the Run of Style itself. And even Run of Style state they want to protect their citizen from the virus, that is still cannot be there justified, because consider Article 27 of VCLT, where no country can defend their own laws country as a justification of violation of international obligations. And hence, Run of Style, as a member of this agreement, may not use their national law as their justification of their failure to carry out this convention, Your Excellencies. May I continue my argument, Your Excellencies?
Yes, yes, you may proceed.
Going to the second submission, going to the second point, Ranovstaya must compensate the economic losses that Ranovstaya has caused to Aprepuya. Your Excellencies, Ranovstaya must compensate over 130 million euro as a form of Ranovstaya's responsibility to Aprepuya, because Ranovstaya compliance with Article 31 in responsibility of states for internationally wrongful act, where Ranovstaya has responsibility to give a reparation as the result of their travel restriction that affect to Aprepuya's economic losses, and Aprepuya require the compensation based on the international wrongful act that covers any financially accessible damage,
Excuse
including
me,
costs.
agent.
Yes, sir.
You mentioned the internationally wrongful act, the draft. Um, what is the status of the draft to the applicant and the respondent? What is the status of the draft in this case, and why does why is it eligible to be the legal basis in this case?
Yes, Your Excellencies, I do understand your concern. Consider the rules of international wrongful act is did not exist in international law, thus as a sources to the Article 38 to the ICJ Statute in the international wrongful act context, ILC recognized as the only one sources that exist and relevant with all civilized nations. And this draft is also already been seen by the International Court of Justice, and in another sample is also used in another court, such as in the Germany court. And this draft also has used in many cases that can be a form of a customer international that that's why Ranobstayo and Aprepuya is relevant to this international wrongful act itself, Your Excellencies.
Okay, you may proceed.
Your Excellencies, moving to the second submission, Ranobstayo violated international law by refusing to hand over Ms. Kambak Verman to the Aprepuya's authorities. Your Excellencies, may I submit on the table two arguments. The first action to accept Ms. Verman by Ranobstayo's consular is indeed violating international law. And the second, Ms. Kambak Verman is not fit with the criteria to be called as asylum or refugee seeker. This issue appear when there is one of the employee in the NBL named Ms. Kambak Verman reported about the cases of the COVID-19 with her fake social media. So that as a consequence, she has been a suspect of a breach of a non-disclosure agreement in Aprepuya's laboratory. Hence, Ms. Verman visited Ranovstayo's consular to grant it an asylum, and Ranovstayo held her and refused to hand over Ms. Verman to the Aprepuya's authorities. Thus, this is the pioneer why Ranovstayo violated international law by not surrender Ms. Verman. Your Excellencies, Ms. Kambak Verman is the fugitive from Aprepuya's justice, and there is no good faith and reciprocity by Ranovstayo to surrender Ms. Verman. As now, Ms. Verman, with her own free will and consciousness, she's committed her domestic law by bound the non-disclosure agreement in the NBL. NBL is a national bioresearch laboratory that's state-owned and state-run by Aprepuya, located in the Segura province. And all employees agree as a condition of employment that they will not disclose any information in the laboratory. And the violation of the agreement is undertaking of the prosecution exercise. As a result, Aprepuya has formally asked for Ms. Verman extradition with the procedure as how international law regulated. And as known, there is no rule of international law could that could prevent the state to extradite their citizen from the other country. And in many practice states, national legislation provides for the possibility of extradition without pre-existing the agreement itself. And allow me to bring the two cases of the extradition without pre-existing the agreement. The first, there's a cases of the Safarkar, Mr. Safarkar, who is a Britain and Indian nationality that has been a fugitive from the British justice. He tried to escape from the British to French, and the court ordered French to hand over Mr. Savarkar to British justice because he is clearly fugitive from the British justice. And the second case is there is a Maria Pauline case which committed 1.7 trillion rupiah bank burglary in Indonesia, and she escaped from Indonesia to Serbia, and Serbia Interpol hand over her to Indonesia because consider Mrs. Maria is clearly fugitive from Indonesia. And thus, your senses, that is why Ranavstaya has to do the reciprocity by hand over Ms. Verman to the appropriate authorities, but clearly this principle was not shown by the Ranavstaya. And precisely in 8 June 2019, Aprilia has sent a public statement to Ranavstaya consulate to hand over Ms. Verman, but Ranavstaya still refused to expel Ms. Verman back to Aprilia's authorities. And further reactions is the practice of granting asylum in the diplomatic mission is not exist in international law. Based on Article 55, Paragraph 1 of VCCR, Ranavstaya as a sending state ought to enjoy the privilege and immunities from the receiving state, which is Aprilia. And also, Ranavstaya has a duty not to interfere in the domestic affair of Aprilia. And this strengthened again in paragraph 2, where the consular premises shall not be used with incompatible manner of the exercise of consular function. Your Excellencies, the function of a diplomatic mission is only to representing, protecting, negotiation, ascertaining, and promoting friendly relations. And there is no function to granting asylum to a person, Your Excellencies. Thus, Ranavstaya clearly violated this international agreement and therefore should expel Ms. Verman to Aprilia back, and because she's not fit with the criteria to be called as a refugee or asylum that could be protected by the other country, Your Excellencies. And furthermore, Your Excellencies, the second point, Ms. Kamban Verman is not fit with the criteria to be called as asylum or refugee seeker. The first, asylum seeker is only a person who has fled their home country because of war or other factor harming them or their family, and they enters another country to apply for asylum. And refugee itself is a person that, owing to well-founded fear of being persecuted for reason of race, religion, and nationality or political opinion. Your Excellencies, Ms. Verman is not fit with to be called as a refugee or asylum from the very first. She is a purely criminal fugitive that violated her own domestic law by taking advantage to run to Ranavstaya's consulate while she is not going to prosecute by the punishment of race, religion, nationality, or political opinion. Your Excellencies, as what declared in the statement of facts number 4, where the violation of the non-disclosure agreement is only to imprisonment over 1 to 20 years, not of a punishment that inhuman act or inhuman punishment itself, Your Excellencies. Thus, this is only misformation prejudice to Aprilia's or authorities while she is the fugitive from Aprilia's justice, Your Excellencies. And the last is the principle of non-revolvement and its relevance for Ms. Verman extradition. This principle is relevant because under this provision, a state may be permitted to expel or return a refugee or asylum seeker to a country where they face a persecution on grounds or of overriding reasons of national security and public safety. And the person who has taken a refugee also must be handed over to the local authorities if
Excuse me.
they have.
In your memorial, yeah, it is said that there is no rule of international law which prevents states from extraditing in the absence of a treaty. So that means there is no extradition treaty between the two countries. Um, And then further, it said that it is subject to the explicit condition of reciprocity. So why do the respondent have to hand over um, Miss Vermont to the applicant? Like, do you have any evidence of reciprocity, or because clearly there is no extradition treaty between the two countries?
Yes, Your Excellencies, I do understand your concern. Why Ms. Froman is have to be handed over to appropriate order this because she's not fit with the criteria to be called as asylum or refugee seeker. Where Ms. Froman is purely a person who is violate her domestic law by bound the non-disclosure agreement that she was consent to it. Where the NBL is only company, the not the the government authorities that see disclose information there. Sees only disclose about the information in the company which is in the anvil and in the National Bio Research Laboratory. Thus, Ms. Verman is only taking advantage by taking asylum to run of status consular while she is purely a fugitive from criminal offense. And if Run of Style constitute her as her asylum is not fit at all, Your Excellencies. For the foregoing reasons, Run of Style require the court to declare that Run of Style violate international law by applied its anti-regulation and must compensate of it, and Run of Style also violated international law by did not want to refuse uh, hand over Ms. Forman to the appropriate authorities. Thank you, Your Excellencies.
I would like to call the second speaker.
Thank you, Your Excellencies. Very good evening, Your Excellencies, Madam President, Veby, and Agent, the Democratic State of Ranabstayu. My name is Ayu Anggraini, and I have the honor to appearing before this court appealing on behalf of applicant, the United States of Australia, representing the case concerning COVID-19 pandemic. Your Excellencies, I will be delivering the third submission regarding to the court may not exercise jurisdiction over run-of-tires counterclaim concerning the maintenance airways aircraft. And for the fourth submission regarding to even if the court were to exercise jurisdiction, Australia did not violate international law by shooting down the aircraft. Your Excellencies, in this third submission, I will submit two main points. Firstly, about the court may not exercise jurisdiction over run-of-tires counterclaim based on Aprepulia and Ranabstayo Declaration of Reservation on 7 January 2002 and 10 March 2003. And for the second main point, the maintained airways aircraft dispute is the domestic jurisdiction of the United Republic of Aprepulia. Your Excellencies, if you don't mind with the structure, may I please the court?
Please proceed.
Thank you, Your Excellencies. I will begin with the problem at all. This issue emerged in the early June of 26, 2018, when a maintained airways aircraft are crashed into territory in Aprepulia authorities. And this maintained airways aircraft is a low-cost charter airline privately owned by Aprepulia, and this aircraft registered in Aprepulia authorities, Your Excellencies. Your Excellencies, the maintained airways aircraft are shot down by the Air Force of military authorities of Aprepulia in order to prevent a tragedy from the surveillance of the suspected FOG operatives in Aprepulia territories. And as the result, both of the passengers, known as Mrs. Kembak Foreman and Mrs. C as the pilot, were killed in this case, Your Excellencies. On 16 July 2018, Ranabstayo notified the court about the wish to file a counterclaim, asserting that the shutdown of the maintained airways aircraft due by Aprepulia are violated international law. But only 2 days later, Aprilia often notes its intention to ask about the court to declare and adjudge that the International Court of Justice has no jurisdiction over this counterclaim, Your Excellencies. Your Excellencies, to prove that the maintained airways aircraft dispute is under the domestic jurisdiction of Aprilia. Firstly, based on the Declaration of Reservation on the Declaration of 7 January 2002 enter March 2003, the International Court of Justice has no jurisdiction regarding to this reservation. As stated in the statement of fact of point 46 that regulate regarding to this reservation, it stated that this declaration shall not apply to any dispute with regard to the military activities and to any matters within the essential with the domestic jurisdiction of the United Republic of Aprilia as determined by the government of the United Republic of Aprilia. Your Excellencies, based on the definitions that regulate in the Article 2(1)(d) of the Vienna Convention 1969 that regulate if the reservations that bind both of the country or the contracting state will be binding under the international law, Your Excellencies. And the action that was took by Aprilia and Anapsayo on their declaration of 7 January 2002 and 10 March 2003 is already comply with these provisions. And the status of these reservations already bind both of this country, which is Aprilia and Anapsayo, Your Excellency. And Your Excellencies, with the second issues that this declaration will be applied to the military activities of the United Republic of Aprilia. As I stated before, that the maintained airways aircraft are shot down by the military air force of Aprilia nationality. And in this case, regarding to the military activities, Aprilia already comply and link to the military activities in order to shoot down this aircraft from the prevent the tragedy of the FOG's attack on their territory. In Your Excellencies, Aprilia is in the condition of the threatening attack from the FOGs as their send the information about the inscription coded by the FOG's organization that they will do an attack toward the civil aircraft in bomb laden as the weapons, Your Excellency. And for the second is the maintained airways aircraft are crashed into the territory of Aprilia. And regarding to the territorial principle and the state sovereignty of Aprilia, and also the maintained airways aircraft dispute is linked to the nationality of Aprilia. And these reasons that can be clearly said the maintained airways aircraft dispute is under the domestic jurisdiction of Aprilia, Your Excellencies. With that reasons, the International Court of Justice
Excuse me,
has
Agent, before you proceed further. So even though the applicant has jurisdiction over the case, do you think it is lawful for them to shoot down the aircraft, the commercial aircraft?
Yes, Your Excellencies, I understand your concern. Regarding to the Article 3BC Chicago Convention 1944, I quote that if the said aircraft enters the airspace of another country without valid authorization, the contracting state can force to land for further investigation or prosecution, Your Excellencies. And also, moreover, in the Article 7 of the Chicago Convention, it stated that it will the contracting state may, for the legal reasons, to shoot down the aircraft in order to protect their interests, Your Excellency. And also, under Article 37
Before
of
you
Chicago
proceed,
Convention
you
1944,
mentioned that for the legal reason, it is lawful to do that. Can you give me some evidence of that legal reason that you claim?
yes, Your Excellencies, I understand your concern for the legal reasons that we took an action to shoot down the aircraft in order to protect our citizens. And the maintained airways aircraft are not comply with the standard operating procedures in our aerial navigation, Your Excellencies. Firstly, the maintained airways aircraft was flying illegally towards our capital city, and it will become a threat to our national your excellencies. And secondly, that the maintained airways aircraft is not registered in our domestic jurisdiction, so we have our legal authority to stop this aircraft. And thirdly, that the maintained airways aircraft is under the jurisdiction of Apreplia based on the principle of
Ini Ayu yang fresh ya? Iya. Kira aku yang fresh. Gimana nih, lanjut kali ya? Oh, udah dia. Continue.
Yeah, please proceed.
Your microphone, you.
Yes, Your Excellencies. And thirdly, that the maintained airways aircraft is under our domestic jurisdiction. So we have our legal basis in order to protect our citizens, and we did not violate any kind of international regulation under the international law by shooting down the aircraft, Your Excellencies. May I continue?
Before you proceed, do you think that the respondent cannot claim any compensation for the shutdown of the aircraft?
Yes, Your Excellencies, I understand concern. On the side of respondent, they claim that we need to compensate at least for the loss of the incident, Your Excellencies. And
Okay.
in
So they can claim for compensation for the incident. That if the ICJ has no jurisdiction over this incident, then how would they ask for compensation to the?
yes, Your Excellencies, I understand your concern. It can be clearly under our domestic jurisdiction, and the International Court of Justice is not more eligible to solve the dispute. And regarding to the compensation that asked by the respondent side, we will do an action in order to comply with the standard operating procedures of this accident, Your Excellencies. But Your Excellencies, Ranov Sayo as the respondent has no interest towards this dispute, Your Excellencies, because Mrs. Kembak Foreman, as they claim as their asylum, is not fit to be called as asylum, Your Excellencies. Mrs. Kembak Foreman is the real fugitive that taking advantage to run of Stayus a consular, Your Excellencies. And we do not kind of what Run of Stayus asked to ask their compensation towards us, because Ranov Tayo has no any interest regarding to this issue, Your Excellency. May I continue, Your Excellency?
Yes, please proceed.
And for the second point, that the maintained airways aircraft dispute is the domestic jurisdiction of Apreplia based on the territorial principle and state sovereignty of Apreplia. As stated in the Article 1 of the Chicago Convention 1944, that the contracting state has their fully sovereignty over its airspace, Your Excellencies. And the maintained airways aircraft are crushed in the territory of Apreplia. Of course, the maintained airways aircraft is under the jurisdiction of Apreplia, and passenger inside the maintained airways aircraft is the nationality of Apreplia. And this maintained airways aircraft is registered in Apreplia authorities, Your Excellencies. So with that reasons, that we clearly said that the International Court of Justice has no jurisdiction toward this dispute, Your Excellencies. And moving to our fourth submission regarding to, even if the court were to exercise jurisdiction, Aprilia did not violate international law by shooting down the aircraft. Here, we submit two main points. Firstly, Aprilia did not violate international law by shooting down the American Airways aircraft based on the state sovereignty of Aprilia that has this authority of Aprilia institution and Aprilia human rights interests. And secondly, that Aprilia complies to the international procedure on international civil aviation as the Maintain Airways was flying illegally towards our capital city, and this violated the provisions of the Chicago Convention 1944, and Apria's good faith to comply the standard operating procedure. Your Excellencies, if you don't mind with the structure, I will continue.
Yeah, please proceed.
Thank you, Your Excellencies. Here, to prove that even if the court were to exercise jurisdiction, Aprilia did not violate international law by shooting down the aircraft. Your Excellencies, Aprilia has the state sovereignty that has this Aprilia institution. As the first, that the international responsibility can be applied to Aprilia, since there was no international wrongful act that made by Aprilia under the international law, Your Excellencies. And based on the convention relating to the regulation of aerial navigation under the Article 1, that regulates complete and exclusive sovereignty over the airspace above state territory. This is more elaborate in turn with Article 1 of the Chicago Convention 1944, Excellency. And the similar regulation can be also found in the Libero-American Convention of the 1st October 1929, in the Pan-America Conventions of the 20 December 1928, Your Excellency. And each contracting state may, for reasons of military activities or necessity or public safety, restrict or prohibit uniformly the aircraft of another state from flying over certain area of its territory. Your Excellencies, the action that was took by Aprilia to shoot down the Maintain Airways aircraft is already comply with these provisions. Based on Aprilia state sovereignty under the international law, Aprilia as a contracting state that binding in the International Civil Aviation 1944, Aprilia comply and eligible to solve these disputes under the domestic jurisdiction and do not violate any kind of international law based on their state sovereignty, Your Excellencies. And also, under the Article 5 of UDHR that regulates Article 3 states everyone has the right to live, liberty, and security of person. And every Aprilian has the right to live, liberty, and security from the threats of the attacks of the Maintain Airways aircraft. As assumed in the Maintain Airways aircraft, there was a spy missions or hijacking action by the apologies organization, Your Excellency. And Your Excellencies, here the Maintain Airways aircraft is fully not honored with the domestic law by the aerial navigation of Aprilia, because firstly, the Maintain Airways aircraft was flying illegally toward our capital city, and it will become a threat in order our conditions is in the armed attack, Your Excellencies, from the FOGs. And for the some facts that FOGs already do an attack in London, Ottawa, and Abuja over the last 3 years. Under the Security Council also lists these organizations as a terrorist organization since 2016. And based on their message that they send to us, to our authorities, they will do an attack toward our capital city by using a bomb laden in civil aircraft. And Your Excellency,
Excuse me, Agent. Can you explain to me the requirement for applicant to exercise their sovereignty, in this case, like to protect themselves from the terrorist group? What do they have to do first before they can shoot down the aircraft and to prevent terrorist attacks.
Yes, Your Excellencies, I understand your concern. Here, the military, air force, and military authorities of Aprepulias already do a warning, a preemptive attack, Your Excellencies. Is to protect our citizens from the threatening of the apologies. Our civilian has to earn preemptive procedure in order to protect the aircraft. Your Excellencies, as before, that we do not directly took an action to shoot down the aircraft because under our efforts by the jet fighter, they do send the visual code first to the pilot of the maintained airways aircraft. But as the result that there was no feedback from the pilot to our jet fighter, and also the shooting down of the maintained airways aircraft at very first is in the hope that there will be do an emergency landing, as our military shoot the root of wings, not directly to the body of the aircraft, Your Excellencies. And it as the result, the pilot do lose the control to protect and save their life in the maintained airways aircraft, and as the result, the maintained airways aircraft was crashed into the forest in Aprepulia territory, Your Excellency. May I continue, Your Excellencies?
Yes, please finish.
Your Excellencies. At the very first, that the maintained airways aircraft was flying illegally and do not comply with the standard operating procedure in aerial navigation in Aprepulia authorities. And Aprepulias already do the principle of good faith toward this action. As know that maintained airways dispute is protected by under the International Civil Aviation 1944. And as this action, Aprepulia and Danuk Tayo already do an investigation under the ILSA. And this investigation is in order to know the incident clearly without any kind of presumptions or assumption, Your Excellencies. And here, by doing this action, Aprepulias already comply with the principle of good faith under international law. And foregoing reasons, Your Excellencies, we respectfully ask the court to declare and adjudge that the International Court of Justice has no jurisdiction over this counterclaim concerning the maintained airways aircraft. And even if the court were to exercise jurisdiction, Aprepulia did not violate international law by shooting down the aircraft. Thank you, Your Excellency.
Yeah, thank you, Agent. I would like to call the speaker, the agent of the respondent.
Yes, Madam President, but I will wait to the timekeeper to set up the time. Very good evening, Your Excellencies, Agent of Aprepulia and the audience. Madam President Veby and Judge Ari, my name is Arimbi Fajari Furkon. It is such an honor to stand in this virtual court pleading to represent the President of State of Ranustau as the respondent in the present case concerning COVID-19 pandemic. I will be delivering this first and second part of respondent submission in the next 21 minutes. My co-agent, M. Yusuf Akbar, will deliver the third and fourth part of respondent submission for 21 minutes. And we also reserve 3 minutes for short battle. If you don't mind about the structure, may it please the court.
Please proceed with your case.
Thank you, Your Excellencies. The first submission is regarding to Ranustau didn't violate international law by applying its anti-regulation to Aprepulia.
And even if it did, it should not be required Aprepia for any claim economic losses. Your Excellencies, we submit three main arguments to prove Ranostayo didn't violate international law. The first, Ranostayo didn't violate international law because it was the state sovereignty of Ranostayo to apply the anti-regulation. And second, Ranostayo didn't violate international law by applying its anti-regulation regarding to the fundamental rights of person. And the third, Ranostayo has no obligation to compensate the economic losses of Aprepia. Now, with the court permission, I will turn to my very first argument regarding the state sovereignty of Ranostayo to apply the entry regulation. Your Excellencies, there were suspected cases of COVID-19 pandemic in Aprepia had appeared in NBL from NBL on 25 May 2018. Aprepia didn't report the suspicious person and failed handle it. Hence, in order to prevent the COVID-19 virus to enter our territory, Ranostayo made the entry regulation that include the list of high-risk countries, where Aprepia was added to that list because the failure of handling the COVID-19 pandemic in NBL. As a global community, Ranostayo cannot continue to ignore the act of Aprepia to fail handle that virus, Your Excellencies. The characteristics of the land of sovereign state is a competence exclusivity of the state regarding their own territory. The sovereignty state is the same as the land and their airspace. Regarding to the Article 3 of the Montevideo Convention, and I quote, the political existence of the state is independent of recognition by the other state. Even before recognition, the state has the right to defend its integrity and independence to provide for its conservation and prosperity. Your Excellencies, for that article I mentioned before, Ranostayo has the rights and full sovereignty about how they want to regulate their country based on the regulation, as it fits for the interest and the safety of their people, and this is what actually Ranostayo did regarding to the entry regulation. It was for the safety of Ranostayan. Your Excellencies, the hasty stance to recommend any restriction on international travel must be understandable, given the availability evidence on the impact and long history of such measures being taken with a little or scientific justification. With a travel ban, it may introduce potentially effectively travel restriction to the goal of the international health regulation to prevent the spread of the public health threat. It's reflected in the emergency health of Ebola on 2014 until 2016, the travel ban legally did, as Australia became the first country to restrict the travel from the 3 West African countries at the centers of the outbreak, and the act was lawful under international law, Your Excellencies. Each state has the right to make any regulation depend on their need of nation, Your Excellencies, as well as maintain and a capable state to handle they have to do in their territory. This statement also supporting by the domain reserve doctrine declared by Austin Hobbes, where the state has jurisdiction to do in their capacity and free from obligation and regulation under international law.
Before
It
you
also
proceed further, Agent, what do you say about the failure of respondent to report to the WHO about the restriction?
Yes, Your Excellencies, I do understand your concern. Your Excellencies, actually, Ranostayo, as a member of the WHO, already report or notified WHO about our entry regulation on 27 April 2018, Your Excellencies. And we already communicate with the WHO to respectfully decline or respectfully disagree about the WHO recommendation about the ban of travel restriction, because Your Excellencies, the ban of travel restriction is regulated under the Article 15 of the International Health Regulation, and also Your Excellencies, in the article under the Article 1 of the International Health Regulation, it regulates the terms that the terms of Article 50 of International 15 of International Health Regulation is non-binding advice from the WHO. So it's not legally binding as the treaty to our country, Your Excellencies.
Yes,
May I
please.
continue? Yes, Your Excellencies, it also emphasized under Article 13 of Universal Declaration of Human Rights, in order what happened on the internal state, its domestic affairs of the state itself, and also strengthened under Article 1 of the Chicago Convention that exclusivity of the sovereign state, that every country has the rights to close off the airspace above its territory from the commercial efforts carried out by the foreign countries. Ranostayo conclude, Ranostayo has the rights to do what they have to do in their territory as long as the desires and interests of Ranostayo. Whereas Ranostayo want to prevent COVID-18 virus from entering the state and especially to all Ranostayan both inside or outside Ranostayo state. Moving to my second argument, Your Excellencies, Ranostayo didn't violate international law by applying precise regulation according to the fundamental rights of person. Your Excellencies, under Article 25, Paragraph 1 of the Universal Declaration of Human Rights, stipulates that, I quote, everyone has the rights to standard of living, educate for the health. What Ranostayo did in the very first step, according to the duties as a country in the global pandemic, is to protect Ranostayan or non-Ranostayan in the classical tradition of the absolute rights of the individual itself, Your Excellencies. And regarding to the Salus Populi Suprema Lex Exto principle by the Cicero's book, the safety of the people is the highest law, Your Excellencies. It also have similarity or interlinked with Article 9b of the Chicago Convention. I quote, during a period of emergency or in the interest of public safety and with immediate effect, temporarily to restrict or prohibit flying over the whole or any parts its territory. Moreover, Your Excellencies, under the Article 19 of the International Covenant and the Civil and Political Rights, Ranostayo has the right to hold opinion and without interference and freedom of expression. Ranostayo has the right to hold opinion and disseminate information about the list of high-risk countries, Your Excellencies. Your Excellencies, moving to my last argument, Ranostayo has no obligation to compensate the economic losses because Aprilia didn't confirm and notify WHO about the employer in NBL are infected by COVID-18 virus. Under the International Health Regulation Article 6, Paragraph 1, I quote, each state party shall notify WHO assessment about the public health information of all events which may constitute a public health emergency of international concern within its territory. Thus, Aprilia didn't respect the international law by didn't report the employer in MBL are suspect by the COVID-18 to the WHO first. Also, Aprilia hide this information and Ranostayo government disappointed because there is so many Ranostayan vacation to the Segura province, Your Excellencies. Your Excellencies, may I continue to my second submission?
Yes, please.
Thank you, Your Excellencies. The second submission is regarding to Ranostayo didn't violate international law by refusing to hand over Ms. Kenbak Formun to the Aprilian authorities. Your Excellencies, we submit three main arguments to prove Ranostayo didn't violate international law. The first, extradition law prohibits Ranostayo to hand over Ms. Famun to Apropria from her political offense. And second, the human rights of Ms. Kenbak Forman was protected by international law. And the third, Ms. Forman information protects public interest. Your Excellencies, Ms. Kenbak Forman is appropriately national born and raised in Segura province. She is the NBL member and signed the NBL non-disclosure agreement on 10 April 2018. But on 3 June 2018, Ms. Kenbak Forman sent the information of disclosure about the Jessup cases in Apropria. By the Twitter account, she cried the government of Apropria keep denying the cases that already exist. And the Aproprian police chased her and she drove through the front gates of Ranostayo's consulate in Segura province. And at that time, the consul agreed to let her stay in unused room in the consulate and become an asylum seeker of Ranostayo by our foreign ministry. I will proceed to my very first argument regarding extradition law prohibit Ranostayo to hand over Ms. Kenbak Forman to Aproprian from her political offense. The act of Ms. Kenbak Forman was categorized as a political offense since she against the government of Apropria from her Twitter, prejudiced her state system of information of Jessup 18. The cases of Jessup 18 in Apropria were hidden by the government in Segura province. So Ms. Kenbak Forman against her government to say the truth about the cases that already exist. And also she against the government by didn't obey the agreements
Mana? Nggak kenapa-kenapa. Keringetan ya?
between the employers and NBL about non-disclosure agreement. Your Excellencies, extradition cannot apply by the act of political offense according to the Article 33(1) of the Convention and Protocol relating to the status of refugee and customary international law. Under this article, I quote, "No contracting state shall expel or return a refugee in any manner whatsoever to the frontiers where his life or freedom would be threatened on account of his political opinion." Your Excellencies, both Apropria and Ranostayo are the parties of this convention, and thereafter, neither Apropria and Ranostayo have the ratification
Iya.
the terms of Article 33(1). And also, Your Excellencies, why this is a customary international law? Because the Swiss representative said that his government have all times applied this principle that states in the article. But the Swiss government wished to have the rights in quite of exceptional circumstances. Further, according to the Model Treaty on
Aku
Extradition,
nyalain AC dulu.
adopted by the General Assembly Resolution 45
Iya.
under Article 3,
Tuh ya.
the natural grounds for refusal extradition
Sama hidupin AC dulu.
to the political offense, and if the requested has substantial grounds for believing that the extradition request has been made to prosecute or punish a person on account of that person's race, religion, nationality, ethnic origin, political opinion, sex or status, or that person possession may be prejudiced for any those reasons. Ms. Kenbak Forman, who did the political...
Before you proceed further, but the respondent can choose not to give asylum to Miss Berman. So why do they have to give asylum to her?
Sorry, Your Excellencies, because the sign now not good. Can you repeat or pardon the question?
Yeah, please proceed. Yes, continue.
Yes, Your Excellencies.
Kenbak
women
Pasangin, pasangin, pasangin.
must be not handed over to Aprilia by Ranulfstyle because according to this regulation, Ranulfstyle cannot expel her and she cannot be returned to Aprilia. Since Ranulfstyle as the state respect to the international law protects her life from the persecution of Aprilia. According to the case that Fitzgerald Haya de la Torre was a leader of a Peruvian political movement, American People's Revolutionary Alliance, which was constantly in trouble with the government, when his movement revolted and lost at one-day civil war on 3 October 1948, he sought refuge in Colombia embassy. Colombia recognized Haya de la Torre as a political offender. However, when analyzing especially to the accusation against Haya de la Torre by the Peruvian government, the court found that he was a political offender and the act of Colombia to accept him as a refugee is lawful under international law. Your Excellencies, the Pan-American Convention on the Territorial Asylum 1954 stipulates similarly that extradition will not be granted if the determination of the asylum surrender of the person concerned is being sought for the political offenses, for the common crimes which have been committed for the political objective or for predominantly political reason. To conclude, Ranulfstyle believed that Aprilia had a purpose to prosecute Miss Kembak Forman because of her information about the case of Jessup in NBL, and Ranulfstyle protects Miss Kembak Forman as our asylum seeker. Going to the next argument, Your Excellencies, the human rights of Miss Kembak Forman was protected by international law. Human rights is a fundamental right since being human is considered to the United Nations purpose about the humanity. The international law instruments support the human rights as a universal declaration of human rights under Article 2, Article 3 about the right to life and security of person. Moreover, under the Article 14 regulates about the right to seek and enjoy in another country asylum from persecution. As a person, Ms. Kembak Forman has the rights to enjoy asylum from the Ranulfstyle as long as Ranulfstyle accept and protect her from the Aprilia. Going to the last argument, Your Excellencies, Ms. Kembak Forman information protects public interest. Public interest is protected by international law, and the general principle of international protects the public interest. Furthermore, on the Legal Services Act 2007, in Section 1, set out the regulatory objective of the protecting and promoting public interest regarding to the foundation justify intervention in otherwise private activities. In other words, the ability individuals or organizations to do what they wish contain in some way to achieve broader active valued by society. Ms. Kembak Forman acts against the government and non-disclosure agreement on the interest of public interest, Your Excellencies. It's kind of public emergency, even the security of her country, and Ranulfstyle respect to the brief of her action to protect Aprilia from the Jessup virus in Segura province. Ranulfstyle as a country respect to the public interest of health from the pandemic of Jessup and protects Ms. Kembak Forman from the persecution of Aprilia because information of Ms. Kembak Forman is useful to the public health of the world. So the foregoing reason, respondent respectfully requests to the court that finds it favor to adjudge and declare that Ranulfstyle didn't violate international law by applying its entry regulation to Aprilia, and even if it did, it should not be required Aprilia for any claim economic losses, and Ranulfstyle didn't violate international law by refusing to hand over Ms. Kembak Forman to the Aprilian authorities. Thank you, Your Excellencies.
Thank you, Adrian. Please proceed with the second agent of the respondent.
Okay. Okay. Very good evening, Your Excellencies, Madam President Veby and Judge Ari Wiryadinata, and the agent of the United Republic of Apapruya. My name is M. Yusuf Akbar. It is such an honor to appear in this virtual court representing on behalf the Democratic State of Ranamstayo as respondent in this case concerning the COVID-19 pandemic between Apapruya and Ranamstayo, where I will speak for the next 21 minutes, and I will be address our third and fourth submissions regarding to the court may exercise jurisdictions over an abstayo counterclaim concerning the maintenance of aircraft and Apapruya violated international law by shooting down the aircraft. Your Excellencies, with your permissions, I will begin to deliver from our third submissions and may it please the court. Your Excellencies, the problem emerged when Ms. Furman, who already an applicant for asylum seeker to Ranapstayo, is intended to manage to get away from the territory of Apapruya. But, Excellencies, in the process, her airplane was shot down by the Air Force of Apapruya. The reasons to do that is because they believe that airplane was used for committing a possible terrorist actions to the capital city of Apapruya. But, Your Excellencies, the recording crash of the Maintain Airways from the conversations of Ms. Furman and Ms. Wei, we can conclude that they never intended to use that airplane for committing a terrorist actions, rather than they only want to get away from the airspace of Apapruya. Because of this, Your Excellencies, we declare that in our third submissions, the court may exercise jurisdictions over an abstayo counterclaim concerning the maintenance aircraft. Your Excellencies, I will deliver to you two submit of main arguments proving that the court may exercise jurisdictions of a run-up style counterclaim concerning the maintenance aircraft, where, Your Excellencies, in the first argument, the court has jurisdictions under Article 36 Statute of the International Court of Justice, and in the second argument, the court has jurisdictions of a run-up style interest on the counterclaim. Your Excellencies, in our first argument, the court has jurisdictions under Article 36 Statute of the Court, where, Your Excellencies, under Article 36, Paragraph 1, Statute of the International Court of Justice, where it provides that, I quote, the jurisdictions of the court comprises all cases which the parties refer to it, and all matters specially provide for in Charter of the Nations or in treaties and conventions in force, unquote, where, Your Excellencies, based on the statement of fact on 17 August of 2020, both Apapruya and Ranapstayo agree to have this dispute to proceed in the ICJ. And, Your Excellencies, this is already fulfilled based on the criteria that regulate in Article 36, Paragraph 1, Statute of the Court. Moreover, that, Your Excellencies, the court may also be granted jurisdictions over dispute arising from international treaty where such treaties contain a compromissory clause, providing for this in fact that, Your Excellencies, while a large number of international treaty, both bilateral and multilateral, do include a clause awarding the ICJ jurisdictions with respect to the question that might arise from the interpretations and applications of the agreement. Your Excellencies, the court also has jurisdictions based on the declarations of Apapruya and Ranapstayo on 7 January 2002 and March 2003, where, Your Excellencies, at that time, both Apapruya and Ranapstayo already deposit declarations with the Secretary General of the United Nations, where under Article 36, Paragraph 2 of the Statute of the ICJ, both declare that accepting ICJ jurisdictions as compulsory ipso facto and without special agreement. Your Excellencies, the question might arise that if the court does not have jurisdictions because of some reservations, it may still have jurisdictions on other basis. Limitations on the court jurisdictions does not affect the declaration itself, where, Your Excellencies, under Article 93, Paragraph 1 of the Charter of the United Nations, I quote, all members of the United Nations are ipso facto parties to the Statute of the International Court of Justice, unquote. Moreover, Your Excellencies, in the Article 36, Paragraph 2, Statute of the Court also has jurisdictions regarding to the legal dispute concerning the interpretations of treaty any question of international law, the existence of any fact which, if established, will constitute a breach of international obligations, and the nature or extent of the reparations to be made for the breach of international obligations. It invoked its own acceptance of the jurisdictions of the court under the optional clause of Article 36, paragraph 2 of the statute. In the article,
Before you proceed,
yeah,
agent, how does the shooting of the aircraft fall into the category of um, breach of international treaty or interpretation of a treaty? Like how does the reservation not how is the reservation not applicable in this case? How is it not relevant?
yes, yes, Your Excellencies, I do understand your concern. Why we state that it is not involved in domestic jurisdictions of Aprilia, it falls under the international dispute, and some reservations can be breached. Why? Because, Your Excellencies, first, we believe that it is the matter of international concern and it is involved in international dispute. Why, Your Excellencies? Because, Your Excellencies, Ms. Furman, to be known that is one of our applicant for asylum seeker. So when her airplane was shot down with or without intentions of Aprilia, it against our interest. So that's why we proceed in this court. Your Excellencies, do be note that some reservations can be breached in the case of when a state involving the use of force, while we believe that, Your Excellencies, the actions of Aprilia shooting down the aircraft is actually involving the use of force, where, Your Excellencies, Sir Herz Lauterfact, one of the most famous international lawyers in the 20th century, it stated that it will appear that the primary purpose of the international court lies in its function as one of the instruments for securing the peace insofar as this aim can be achieved through law. What it means by this and what I intended to say that, Excellencies, the very purpose of the International Court of Justice is to keep international peace and security when in the case of involving use of force. For example, in the case of the Nicaragua, the paramilitary activity in and against of Nicaragua from the United States of America, the court has jurisdiction regarding to the use of force that involved in the United States of America and the Nicaragua, where, Your Excellencies, the court can sometimes breach some reservations made from the United States because of the risk involving use of force that was involving and contrary to the international peace and security. So that's why the ICJ at this case of the Ms. Furman, the shooting down, Your Excellencies, can exercise its jurisdictions because there is some breach of the use of force, where Kofi Annan, Your Excellencies, at the time of the invasions of Iraq made from United States of America in 2003, he stated that every country, every member party of state must uphold the very principle of the non-use of force, Article 2, Paragraph 4, Charter of the Nations. So when there is a breach, the ICJ can exercise jurisdiction because it involves the use of force, Your Excellencies. May I continue, Your Excellencies?
Yes.
Thank you, Your Excellencies. Your Excellencies, in our second argument, we state that the court has jurisdictions over an abstaining interest on the counterclaim, where, Your Excellencies, the court has jurisdictions regarding to the abstaining counterclaim over shooting down the Midtown Airways, where, as stated on the Article 36, Paragraph 2 of the court, Your Excellencies, we believe that Aprilia has violated international law by shooting down the Midtown Airways because, Your Excellencies, the actions of shooting down Midtown Airways are violated in Chicago Conventions 1944, especially in the Article 3 bis A, where it provides that each state must refrain from using weapons against civilian aircraft. Moreover, that, Your Excellencies, the Aprilia actions on shooting down the Midtown aircraft also violated Article 2, Paragraph 4, Charter of the Nation, as I mentioned before. And in the Article 1 of the state that every internationally wrongful act of a state entails the international responsibility of that state. Your Excellencies, Aprilia actions towards shooting down the Midtown Airways is indeed violated international law, especially in the Chicago Conventions on Article 3 bis A and Article 2, Paragraph 4 of the Nations, and also, Your Excellencies, considering the fact that Ms. Furman, which is one of our applicants for asylum, is also our interest. And Appropriate actions for shooting down the aircraft is absolutely fall under jurisdiction of the court. Your Excellencies, moving to our fourth submissions regarding to Appropriate violated international law by shooting down the aircraft. Your Excellencies, every civilian aircraft is under protections of the Conventions on International Civil Aviation. The actions that was took by Appropriate to shooting down maintained aircraft is indeed violating international law, where based on the Article 3 bis, as I mentioned, that provide protections of civilian aircraft from the use of force against it. And that's why, Your Excellencies, allow me to deliver you to submit two main arguments proving that Appropriate violated international law by shooting on the aircraft. Your Excellencies, in our first argument, Appropriate is violated international law for shooting down military airways because, Your Excellencies, there are prohibitions of using air forces against civilian aircraft. Your Excellencies, the prohibitions of armed forces against civil aircraft follows an international norm. Until 1928, the use of force was a natural component of state sovereignty. That year, the Caleb-Bryan Pact became the first conventions to establish the non-use of force as principle regulating international relations, a rule that taken up by the Charter of the Nations and upheld by the International Court of Justice. And, Your Excellencies, most of the legal theories consider that the non-use of weapons as a peremptory norm of international law, also called jus cogens. This principle, Your Excellencies, is actually bring an impact on civil aviation to the extent that a state may not use armed forces against a commercial aircraft. An addendum to Article 3 of the Chicago Conventions tell us that, Your Excellencies, also that the United Nations General Assembly took up the conventions of the addendum of Article 3 bis A of the Chicago Convention by asking all states to take the necessary steps to avoid incidents involving attacks on civil aircraft that accidentally stray from their fixed route. Similarly, also that, Your Excellencies, the International Civil Aviation Organizations on several occasions has upheld the principle of protecting civil aircraft. The Assembly, Your Excellencies, I quote, condemns all acts of violence which may be directed against aircraft, aircraft crews, and passengers engaged in international air transport, unquote. Also, Your Excellencies, the United Nations Security Council, resolutions number 1067, I quote, condemns the use of weapons against civil aircraft in flight as being incompatible with the elementary considerations of humanity, the rule of customary international law as codified in the addendum Article 3 of the Chicago Conventions. Additionally, Your Excellencies, in order to make the principle of the non-use of weapons more effective, the Chicago Conventions provide for launching and investigations in case of destruction of civil aircraft. Your Excellencies, although as known that based on the statement of fact, Appropriate already obey some regulations in the Chicago Conventions that provide when there is an accident involving the civilian aircraft, there must be an investigation to commit. Where, Your Excellencies, even though Appropriate already still managed to investigate the crash of Maintain Airways, but the recording of the plane shown that the passenger of Maintain Airways is clearly not intended to use their aircraft as terrorist actions rather than just want to get out from the Appropriate airspace. This is clearly, Your Excellencies, degrading of human rights of the person in board, and the actions that was took by Appropriate is frivolous.
Excuse me, agent.
Yes.
In this case, the aircraft does not follow the instruction by the air traffic control by the in the territory of the applicant's country. So, do you think they are still eligible? Do you think the aircraft, the flight itself, is eligible to be considered a mere civilian aircraft?
Yes. Yes, Your Excellencies, I understand your concern. We aware that the flight of Maintain Airways is actually illegal because there is no proper authorizations made from ATC from the Maintain Airways. But, Your Excellencies, it doesn't matter. Why, Your Excellencies? Because Article 5 of the Chicago Convention provide the protections of the non-scheduled air surface aircraft. So, Your Excellencies, we known that Miss Verman flight is illegal, but Your Excellencies, their aircraft is actually legal, and that was under register of tail number A7B and P, Your Excellencies, that was belong to the Maintain Airways. Sure, the flight was illegal, but Your Excellencies, as I mentioned, that Article 5 Chicago Conventions still provide protections of illegal aircraft without proper authorizations. And also that Your Excellencies, we also state that the use of force against Maintain Airways is excessive because there are some rulings that finding, Your Excellencies, the use of lethal force was excessive. Allow me to mention, in the case of the Nachofa case judgment, the following term, I quote, Your Excellencies, there can be no necessity to put human life at risk where it is known that the person to be arrested possesses no threat or limb and is not suspected of having committed a violent offense. Even, Your Excellencies, if a failure to use lethal force may result in the opportunity to arrest the fugitive being lost. Unquote. Your Excellencies, from that statement of ruling, allow me to tell you that, Your Excellencies, Mintian Airways is a civilian aircraft, not a state aircraft. And, Your Excellencies, it must be considered as a non-threat. Even, Your Excellencies, if Apre deemed as a threat to their nations, Apre only play best on their assumptions. And, Your Excellencies, such assumptions is danger in the case when the lack of evidence. Also, international law never universally accept to recognize based on the preemptive attack, and thus, Your Excellencies, Apre actions to use lethal force is excessive, and we believe Apre must be responsible at all costs. May I continue, Your Excellencies?
Yes, please.
Yes, thank you, Your Excellencies. Your Excellencies, I will move to my second argument, which is the right to life of every person on board of Maintain Airways. Your Excellencies, everyone have the right not to be arbitrarily deprived of life. For that, the life of Miss Furman and Miss Wei must be preserved at all costs. The actions that was taken by Aprilia for shooting down Maintain Airways is actually violating Article 6 of the International Covenant on Civil and Political Rights, and therefore Aprilia must be responsible at all costs. Your Excellencies, as I mentioned that Article 6 of the ICCPR provides that every person has the right not to be arbitrarily deprived of life, and Your Excellencies impose a correlative obligations upon state parties to respect that right and to ensure that persons subject to their jurisdictions are not arbitrarily deprived of their lives. Similar protections and many states also make similar protections regarding to the right to life to person. Such example, Your Excellencies, the American Convention on Human Rights, the African Charter on Human Rights, and the League of Arab States on Human Rights. Your Excellencies, Ms. Furman and Ms. Ye is the victim of the term security, like the term terrorism, is one that brings with it both theoretical uncertainties and considerable emotional baggage, and one must avoid, Your Excellencies, allowing the use of broad terms such as security to cloud our understanding of the substance of state duties in respect of the individual right to life in a purely law enforcement context, where, Your Excellencies, we believe that Ms. Furman is the victim of the frivolous labels such as terrorism, because Ms. Furman is actually the victim of the baseless and without solid evidence regarding to the possible terrorist actions. Sadly, because of that labels, Miss Furman's life has been lost because of the victim of the frivolous label such as terrorism. Therefore, Your Excellencies, even if Aprilia thinks that Miss Furman's death is the cause of the incident, they still must be responsible. Because why, Your Excellencies? Philip Alston, in the United Nations Special Rapporteur, say that killing of anyone other than the target of the family member or the vicinity will be an arbitrary deprivation of life under human rights law and could result in a state responsibility and individual criminal liability. What it is mean by
But
the Philip
excuse
Alston?
me,
Yes.
Ms. Vermond is an asylum seeker that is protected by the respondent's country. what is the legal standing for the respondent's country in this case, in this incident? What is the legal standing?
Yes, Your Excellencies, regarding to the status of the Miss Perman who was already an our applicant for asylum seeker, actually, Your Excellencies, in the Convention on Status of Refugee, when someone is already permit to be considered as a asylum seeker, he or she or the person have the right to be protected under a state who actually give their granting for status of asylum seeker. Such example in the case of Victor Raul de Hayatori, in the case of the outbreak of civil war in the Peru, Colombia granting that person an asylum seeker, and that person is actually become under the protections of the state who granting asylum, even though that, Your Excellencies, it is the granting from the consulate or embassy of the sending state. So actually, that's why, Your Excellencies, we feel that it is contrary to our interest regarding to the death of Miss Perman. Your Excellencies, my time is up. May I continue my arguments?
Yes, please finish your.
Okay, Your Excellencies, so that's why we believe that the death of Miss Perman is actually our interest, because the status of refugee we already granting to her, and it has become our protections, and the actions of Apripulia regarding to the shooting non-documented areas is actually contrary to our interest, and we believe also violated international law, especially in the Chicago Conventions and the Charter of the Nations, as we mentioned before. And to conclude that, Your Excellencies, the opinion of International Court of Justice in the legality and the threat of use of force might also be understood that international human rights law does not allow for incidental deaths of innocent person in a law enforcement context. So, Your Excellencies, we also believe that Ms. Perman is the victim of the law enforcement context of Apripulia. So, any kind of actions, as Philip Alston stated, any kind of reasons of person to be lawless killing in a law enforcement context cannot be acceptable. So that's why, Your Excellencies, if Apripulia state that their action for shooting down military airways is incidental or in the context of law enforcement, that kind of excuse must not be acceptable, and therefore Apripulia must be responsible at all costs. Thank you, Your Excellencies.
Oke, mungkin nggak usah pakai rebuttal dan suri battle ya, langsung komen aja masukannya dari Veby, terus mungkin tips and tricksnya.
Oke. Udah apa? Pertama, terima kasih for having me di sesi latihan teman-teman. Dan sorry ya kalau ada suara-suara bayi. But anyway, jadi overall sih udah bagus ya menurut saya. Kayak apa ya, basic tentang pengetahuan fakta-fakta dari dispute tersebut, legal basis yang digunakan, apa statusnya, dan maksudnya dari pertanyaan-pertanyaan tadi itu sudah, menurut saya sudah bisa dijawab dengan baik. Paling minor feedbacknya apa ya? Untuk kayak dari menjawab, misalnya kan judges-nya nanya nih, terus I do understand your concern, kayak gitu kan ya. Kalau menurut saya ya sopan sih, tapi jadi kayak template gitu loh. Kalau misalnya dari segi manner, jadi yang saya pelajari adalah kalau di Jessup itu manner matters gitu ya. Selain juga substansi. Maksudnya kan kalau substansinya udah bagus nih kan tinggal diperbaiki mannernya aja ya. Nah itu di mannernya paling ya agak lebih natural aja ya. Yang saya note yang agak lebih luas tadi speaker yang second speaker dari responden itu si namanya siapa, Jessup ya, itu udah bagus sih, udah luas, tapi maksudnya ada speaker lain yang masih seperti template. Jadi kalau menurut saya misalnya kadang-kadang kan cara judges itu nanya kan beda ya, kadang pertanyaannya yes or no question gitu atau gimana gitu. Nah kalau misalnya ketika yes or no question ya kita yes kan aja, tapi ya tunggu sampai judge-nya juga selesai ngomong gitu. Susah sih gimana misalnya nanya contoh nih, gimana contohnya Kak gitu. Itu sebenarnya lebih ke apa ya? lebih ke feeling aja sih ketika kita ngomong bahasa Inggris gitu kan, kita pede aja kalau bahwa sebenarnya kan kalau muting ini kan kita role playing ya, kita memainkan peran gitu, memainkan peran menjadi legal counsel, kayak menjadi penasihat hukumnya si ini kan, si pihak-pihak yang bersengketa kan. Nah jadi ya kita benar-benar menjadi orang tersebut, kita benar-benar menjadi penasihat hukum yang sedang berperkara di ICJ. Jadi anggap aja gue English speaker dan segala macam, gue pantas berada di sini dan ya ketika menjawab confident. Jadinya ketika kita confident tuh nggak terlalu yang menggunakan template sekali gitu, go with the flow aja. Tapi itu minor banget sih, maksudnya itu nggak akan jadi masalah besar, cuman menurut saya ya bakal jauh lebih indah dilihat dan didengar gitu kalau misalnya itu bukan repetition, pengulangan. Mungkin bisa dilihat cara misalnya kalau ada video gitu ya, video international round, gimana sih cara mereka menjawab atau merespon pertanyaan dari judges-nya, itu kata-katanya seperti apa, kata-kata transisinya seperti apa, kayak gitu sih paling. Sama apa ya, tadi kayaknya ada yang nggak kejawab karena ini ya, karena waktunya udah mepet gitu, terus mau ngelanjutin arguments. Kalau saya sih mikirnya gini, jawab aja sedikit gitu, benar-benar sesimpel mungkin sehingga dua-duanya bisa ke address. Itu best case scenario ya, itu skenario paling bagus. Kalau misalnya memang harus memilih satu di antara dua, merespon judge atau melanjutkan case, kalau saya bilang sih respon aja judge-nya gitu. Nah gimana kalau case-nya belum selesai gitu misalnya, masih banyak nih yang harus disampaikan, ya kita bikin itu menjadi sangat brief gitu. Karena kan sebetulnya sudah ada di memorial ya. Jadi kalau misalnya di penyampaian itu kan ada faktanya, ada legal basis-nya kan. Nah, di faktanya nggak usah terlalu panjang. Ketika misalnya waktunya mepet nih, di faktanya nggak usah terlalu panjang, langsung di legal basis-nya aja. Dibuat simple aja. Jadi sebisa mungkin pertanyaan judge-nya itu direspon. Kalau saya ya harus milih satu di antara dua gitu kan. Ya saya bakal lebih mengutamakan menjawab judge-nya. Kayak gitu. Tapi ya sebetulnya pinter-pinter kita inilah ya, manage waktunya. Kayak gitu sih paling. Kalau misalnya global rounds ini kan saya nggak tahu ya, maksudnya nanti dia bakal menilai manner tuh seperti apa gitu loh. Tapi kalau misalnya dari oral presentation-nya aja, ya kayak gitu sih paling.
Ada lagi, Pep?
Enggak sih, udah bagus kalau menurut saya sih udah bagus. Overall kayak arguments dan pengetahuan yang lainnya udah dapet, paling itu aja sih.
Oke, mungkin teman-teman ada pertanyaan dulu nggak? 1 atau 2 pertanyaan, terus kita closing.
Mbak, boleh bertanya?
Sorry Ari, ada yang lupa. Ada tuh tadi yang apa ya? If you're pleased with the structure apa gimana gitu, gue lupa kata-kata persisnya. Kalau menurut gue nggak usah ditanyain kayak gitu sekali gitu, karena ya udah emang just-nya bisa nggak setuju gitu. Emang just-nya kalau nggak happy terus mau diganti-ganti kan nggak mungkin juga gitu. Dia tidak punya pilihan lain selain menerima itu. Jadi kalau menurut gue ya nggak usah ditanyain aja. Biasanya ya kalau yang gue denger di mood gitu, dia cuma bilang gini aja, saya bakal menjelaskan ini, partner saya bakal menjelaskan ini, may I please the court gitu aja.
Kalau kata lain dari I do concerns itu, Pep, karena kayaknya kemarin kita juga kekenanya di situ sih, kayak ada repetition yang berulang-ulang kan, mungkin
gimana ya, kalau menurut gue di yesin, maksudnya regarding that atau apa gitu loh, kayak lo nggak perlu menjadi sangat-sangat formal sampai jadinya template gitu, karena menurut gue yes aja atau lu sebetulnya tidak pakai transisi aja itu udah nggak masalah sih, sepanjang ya lu nggak, maksudnya kan kita di sana nggak mungkin juga menjadi sangat informal gitu kan, nggak mungkin ya. Maksud kita bilang aja I do understand atau yes regarding that, kayak gitu aja. Kalau menurut gue ya itu udah cukup sopan sih, biar ganti-ganti gitu kata-kata.
Ya, biar ganti-ganti kan, biar varian kan dia kan maksudnya.
Iya, jadi nggak kelihatan sekali kalau itu ngafal gitu loh. Paling ya itu yang kalau Anda senang dengan strukturnya gitu, itu menurut gue di-cut aja sih. Nah.
Oke, ada pertanyaan guys, 1 atau 2?
Boleh bertanya, Mbak?
Iya, boleh.
Mbak, tadi saya ada menyorot pertanyaan dari Ayu. Nah, tadi Mbak kalau nggak salah bertanya tentang, kalau nggak salah saya dengar ya Mbak ya, karena sinyalnya juga putus-putus, itu di mana Mbak bilang apakah responden itu berhak mendapatkan kompensasi tentang jatuhnya maintain airways itu. Nah, kalau nggak salah Ayu tadi jawabannya itu di asilum ya Mbak. Tapi kalau menurut saya itu kurang tepat aja. Yang lebih apakah tepat menjawab itu gini Mbak, teritorinya aplikan. Tentu tidak tepat dong sebenarnya kalau responden itu meminta kompensasi.
Iya.
Minta kompensasi. Nah, ini tepat nggak Mbak kalau kita cuma jelasin itu atau perlu dasar yang lebih lagi gitu? Karena kalau kompensasi itu harus ada kategori injury-nya. Harus ada injury baru bisa compensate gitu. Kalau yang kami baca di intro.
Kalau menurut saya ya, kalau bisa misalnya menjelaskan setajam mungkin itu lebih bagus. Jadi kalau misalnya jawabannya cuma kayak tadi doang, gitu. Sepanjang itu tidak diadres sama jurinya atau tidak diadres sama lawannya, sama aplikannya misalnya, ya itu bakal menjadi argumen yang istilahnya masih berdiri. Jadi kalau ya gimana ya, untuk menghindari argumen seperti itu dianggap benar lah istilahnya ya jangan dikeluarkan gitu. Kalau bisa ya present your best argument, kayak ya memang analisanya dimainkan dan itu yang disampaikan. Jadi memang kamu hindari jurinya atau si lawannya ngulik-ngulik itu, gitu sih Pak. Kalau kata saya, memang seharusnya begitu, memang harusnya ya tajam kayak gitu. Kita sudah antisipasi duluan. Cukup jelas?
Iya Mbak, makasih ya Mbak ya.
Iya.
Satu lagi mungkin. Ada lagi nggak? Kalau enggak, kita foto kali ya. Kamu prepare nggak di situ?
Kenapa?
Kamu lagi nyaman nggak? Kalau iya mau buka kamera, mereka nggak kenal kamu yang mana?
Oh, gue lagi ngurus anak. Bisa sih bentar ya. Apa-apa. Gue cukup pede. Gue cek bentar ya.
Oke.
Gue cek dulu kameranya gimana ya.
Kamu mereknya kasih tahu, Au. Ya.
Halo.
Ya gue hidupin dulu.
Hai. Ya ketahuan deh ibu-ibu.
Hai, siapa namanya Pep?
Marvin.
Karena kamu udah balik ke Jakarta ya?
Iya udah, dari setahun yang lalu lah.
Di law firm jadinya, di mana?
Belum.
Oke.
Belum ada. Ada sih, tadinya mau ke Vietnam, tapi nggak jadi.
Oke.
Corona.
Tapi di ini kemarin HI juga kan ya di Korea?
Enggak, komersial.
Oh, komersial lo. Perdata dong berarti ya?
Iya. Bisnis. Biar ada duitnya.
Oke lah, kita foto.
Oh my god, foto nak.
Gak
Ikut
apa-apa. It's good.
Nggak?
Ayo. Udah Arin Bi.
Oh, belum Arin Bi ya? Bentar.
Ayo, mungkin abang lah.
1, 2. Dah.
Oke. Veby, thank you so much ya udah bantu.
Ya, makasih juga.
Masukan dari kamu juga. Sehat-sehat selalu. Pokoknya nanti kalau ada tim UNAN yang akan ikut juga, kamu harus balik untuk jadi tim.
UNAN nggak ikut katanya. Sebelum
Ya, kita udah marah-marahin tahu.
tanya dulu, mereka nggak ikut, gimana ya? Kalau nggak usaha ya gitulah.
Ya parah banget, sekolah itu nggak berubah dari zaman kamu dulu sampai sekarang masih gitu-gitu aja.
Nah, iya emang nggak ketolong lah udah. Padahal kan kapan lagi gitu kan global
Iya,
ranks.
udah
So,
dibilang sama Ramzi kan. Ramzi kan bagus ya bahasa Inggrisnya kan. Kamu pokoknya harus ikut, kamu harus ikut pokoknya. Iya, terus tiba-tiba nggak ada daftar dia.